Hello, everybody. Welcome to the February chapter meeting of the FPA of Central Ohio. Thank you for joining us virtually today. We are very hopeful that we're going to be back live again in person next month if things keep going the way that they are, if the trends continue. So we're fingers crossed for that. That's what we all want. So we want to be in person and seeing you all face to face again, hopefully very soon. But we're excited for what we have in store here today. I think we have a really great presentation, so we'll get right to that. But I did want to take a second to recognize all of our chapter sponsors. We have some really great partners this year. Our 2022 Platinum sponsors include Calamos Investments, Charles Schwab, Fingard, First Eagle Funds, Palladium Group, and Vanguard. So really great group of folks as our platinum sponsors this year. And then we also have our gold sponsors, ARM CPAs, Capital Group, Diamond Hill, Lord Abbett, and Park National Bank. So please support the people that are supporting us. Some really great firms and great people that are involved with all of them. So if you already interact with them, that's great. If you don't, please take their phone calls or reach out to them, have lunch with them because they're really great people and we're happy that they're supporting all of us and what we do. Did want to mention as well that we are finalizing our new board members this week. So you're going to be seeing something about that very soon and have a chance to vote on a ballot just to verify the candidates that we have. We have 3 open seats and we had 3 applications for those 3 seats. And I think they're really great candidates. So I don't think anybody's going to have a problem with who is stepping in on those seats, but we did want to offer up a ballot to you guys. So just be on the lookout for that here very soon. And then also next month, keep your calendars marked for our chapter meeting. Again, we're very hopeful that we're going to be live again with that meeting. And it's a big one. It's a collaborative meeting with the CFA chapter here locally. Whenever we do that, we always have a really great event. And First Eagle is going to be presenting their macro view of the market. So it's going to be a really timely presentation for them, probably some really interesting conversation I can imagine. Last thing before we get into the presentation, a couple things. We'll have Q&A at the end. If you want to ask questions, you need to turn your camera on, unmute yourself to ask those questions. So just be aware of that as we get to that time. And then also the poll questions that will pop up. If you need Ohio CE, there will be 3 poll questions that you need to respond to in order to get that CE. The CFP CE does not require the poll. So just be cognizant, be aware of that. And obviously, hopefully you're paying attention anyway, so it won't matter. So with that, I want to go ahead and transition here to our special guest speaker today. Amanda is from Carlisle, Patchen, and Murphy, and she concentrates her entire practice on estate planning, probate, and trust administration. She steers her clients through all aspects of estate planning, including drafting all the legal documents, structuring financial assets to reduce transfer taxes and probate costs, navigating estate administration process, and counseling trustees of family trust and proper exercise of their duties. She endeavors to ensure her estate planning clients know and understand the options for how and when their assets will be distributed according to their wishes. Her legal passion was ignited during a time in the financial industry. Amanda noticed a gap of information and has often meant seeing individuals struggling with difficulties surrounding incapacitation, probate, and trust administration. So today, her understanding of financial institutions' inner workings helps her clients avoid and navigate various pitfalls. So Amanda, thank you for joining us today virtually. We're excited to hear what you have to teach us all about.
Thank you, Mark. Am I beginning the presentation or were there slides that Debbie needed to go through?
You're good. You can go ahead.
Okay. Give me 1 second to share my screen. Maybe. There we go. And everyone can see the slides? We're good?
Yep, looks good.
Okay. So Mark covered a lot of my background, but to be a little bit more specific, I graduated from the Ohio State University in consumer and family financial planning. So my undergrad degree basically was designed for people who wanted to be CFPs. I decided to start working at Huntington as a banker after I graduated from undergrad. And while I was there, I did notice that nobody wants to think about dying, for one. And the difference between what the financial institutions wanted and what the lawyers and the courts wanted, there was kind of a disconnect on whose legal department is saying what. And I thought that my background in banking would help me if I decided to go into law to do estate planning and probate. So that's kind of my background. I started out in banking. I went to Capital as a part-time law student while still working at the bank. I ended up switching to being a full-time law student just because it was a better balance at the time. It is very hard to be a part-time student, full-time employee. But after I graduated in 2018, this is what I went into, was estate planning, probate, estate administration. So with that background, let's get into our presentation about same-sex and non-traditional estate planning. Now, for the purpose of this presentation, I'm going to mostly use the language of same-sex versus opposite-sex couples, just for the sake of clarity and presenting to you now. Of course, not everyone perfectly fits into the boxes of same-sex and opposite sex, as you can have a gay couple where one person is trans, or a couple involving a person who is intersex or outside the gender binary. And the legal definition of sex as opposed to gender isn't always defining, because some states will allow you to change the sex that appears on your birth certificate, but the circumstances of doing that really vary by state in terms of, do you have to have gender confirming surgery first? Do you have to live as your correct gender for so long before they'll let you change your birth certificate? So just to kind of get all of that out of the way in terms of gender and sex are complicated issues, but we have an hour-long presentation, and I really don't want to spend most of my time just trying to cover all of the bases of what we're discussing. So for what we're talking about now, I'm just going to use the terms same-sex relationships, opposite-sex relationships, so we're on the same page of what exactly we're trying to cover in terms of estate planning. This was a much harder conversation before 2016 because same-sex marriage was not legal in all 50 states. Between 2004 and 2015, there were about 36 states that recognized same-sex marriage to some extent, but that is clearly not all 50 states, which is what led to the Supreme Court case Obergefell v. Hodges, which was decided in 2016, establishing that marriage is marriage was already a fundamental right guaranteed by the Constitution. Obergefell clarified that same-sex marriage was also covered by that fundamental right to marry. So therefore, you had the right to marry someone regardless of their gender and your gender. And honestly, for the Ohio cases that were comprised within Obergefell, because Obergefell was a hodgepodge of a bunch of cases from different states, both of the Ohio cases had to do with a spouse who had passed away. Both gay couples from Ohio had gotten married somewhere else. They came to Ohio and lived here. Their spouse passed away here, and the Ohio registrar wouldn't put the surviving spouse's name on their death certificate because under Ohio law, we didn't recognize same-sex marriage. And as I'm going to talk about later in this presentation, there are a lot of factors that there are a lot of protections that Ohio law grants to a surviving spouse that's not granted to an unmarried partner. So having that language of just being listed as a spouse on a death certificate is very significant legally in the state of Ohio and across the United States, which is why this was an issue and why we needed to have this kind of recognition from the Supreme Court that this right existed. So Now we're here. Same-sex marriage is legal in the United States. But what did we do before Obergefell? So a lot of the estate planning before Obergefell was similar to what we do for just any unmarried couple now. So any person who's living at this time should probably have a healthcare power of attorney, a financial power of attorney, a living will, if that's what they choose to do, and a last will and testament. Quick overview, I'm assuming most of you know, but healthcare power of attorney will allow someone to make healthcare decisions if you are unable. Financial power of attorney allows someone to work with financial institutions on your behalf. Ohio statutes, there are powers that you can give a financial power of attorney, but you have to specifically list them in that power of attorney. So they can make gifts on your behalf to charities or to family members. They can create a trust for you. It really depends, but you can give a financial power of attorney a lot of the abilities that a spouse would have, even beyond what a spouse would have. And that is why prior to Obergefell, these were the kind of documents that we had to use in order to create the same kind of legal significance that married couples had. Now, for after death planning, obviously you wanted to have a will that stated where you wanted your assets to go. But for after death planning, it was also significant a lot for the same-sex community to have revocable living trusts, irrevocable trusts, specifically to keep their assets out of probate and to keep their assets out of the public record. Because if you have a family that's unsupportive of your lifestyle, you don't want that family to be able to walk down to probate court and see how much money you had upon your death and try to contest your will and receive whatever is in your estate instead of your preferred partner. So the benefit of these documents, particularly trusts, is we get those assets out of probate court, we get them out of the will contest situation, and it's much harder for unsupportive family members to try to make the process even harder for your grieving partner in the circumstance that you pass away and they want to cause problems. Now, the domestic partner, domestic union relationships. So a lot of states, even local municipalities, Columbus was one of them, would allow you to basically sign an agreement saying that we are not married, but we're domestic partners. We live together, we pay bills together, we have joint accounts together. We're basically everything but married in name. And a lot of corporations would allow domestic partners to receive some kind of benefit that was only reserved to family members with those kind of domestic partner agreements. So you could try to get your spouse on your health insurance. You could try to get them life insurance purchased through your company. If your company offered life insurance both for you and other members of your family at a discount. There were a lot of soft benefits through HR departments that you could typically take advantage of with a domestic partner agreement that you wouldn't be able to take advantage of otherwise before you were allowed to be married. Those types of partnerships still exist, but again, it's very, very state specific, even city specific. Ohio in particular doesn't have a domestic partnership law. Ohio, as I'm going to discuss later in the presentation, is very marriage focused. They want couples to be legally married. So you would really have to know where your client is living and what laws are applicable to them if they wanted to take advantage of that kind of agreement now, or if we decided to time travel to go back before 2016. Real estate contracts is the same thing in terms of if you wanted to buy real estate with someone, how to do that in a way that was fair to the both of you. If one person was bringing more of a down payment, or if one person was going to pay more for the utilities or for the actual mortgage, how you wanted to divide that in the circumstance if you ever sold the parcel. Those would be the kind of things that you could determine through contract that are the same kind of considerations you would make if you were doing a prenup for getting married. So that's pretty much everything that we had to do beforehand. And honestly, what we can still do now for couples, same sex or opposite sex, who do not have an interest in being legally married. We can still create the kind of legal powers that we want our partners to have, regardless of whether or not we are married. But the question becomes, what exactly does marriage do? Now, I am currently the administrator of an estate of a gay man who passed away very suddenly, who was not legally married to his spouse. They only had a domestic partnership agreement, and he did not have a will or any planning documents. So his estate legally would go to his mother, who lives out of state and hasn't seen him in 2 decades. So on top of a failure to plan, the other issue with not being married is there are a lot of legally significant acts of marriage that can affect your estate planning. And I really think that an important part of any presentation about same-sex marriage would include this topic of why do I need to get married? Because there is a non-zero faction of the LGBTQ community who doesn't see marriage as necessary because they couldn't do it for so long. Rachel Maddow has a quote where she argues that people were not able to get married for generations and they had to come up with alternative means of recognizing relationships. And she worries that if they have access to the same institutions, that they lose the creativity of subcultures of making it their own. And she likes gay culture. And I don't want to disagree with Rachel Maddow. She is a great news person. However, if we're talking about estate planning, there are lots of benefits of marriage. And if we want to tell our clients what they need to do with their money and the effects of their money after they pass away, we need to address what exactly happens with marriage and why we would want to be married. So one factor would be retirement accounts. So if you have a non-spouse as the beneficiary of your retirement account, they do not have the same ability to withdraw from that account and to stretch out that account in the same way as a spouse. So before the Secure Act, it was a little bit better in that if you listed a non-spouse on a 401k IRA account, they could roll that over into an inherited IRA, and they would have basically whatever was left of their lifetime to make distributions. So the IRS said you must immediately start making distributions the year after you inherit your inherited IRA. That required minimum distribution will be based on your lifetime. So I'm 30 years old. If the IRS actuarial tables say I'm going to live to 80, I have to take out 1/50th of the inherited IRA in the year that I received it, technically the year following the year of death. So the year following the year that I technically would have started the process, and I was required to take out that little bit each time. The way that the law changed with the Secure Act in 2019 is as long as you are not a minor and not disabled, you have 10 years to get rid of all the assets in the retirement account. So if I inherited a 401k or IRA account from my partner, who I am not married to, I would have 10 years to take that money out, and I could take it all out in year 1 or none out in year 1 and take everything out in year 10. It gets rid of those required yearly distributions, but it also cuts down the period of time in which I can withdraw all those funds. And this is not ideal for me because theoretically the next 10 years of my life will be relatively high earning years because I am a relatively young professional. Whereas if I had that 50-year life stretch, I would have time to slow down closer to retirement and take those funds out more towards my retirement as opposed to taking them now. So for the Secure Act, it's really affected our ability to plan for retirement accounts, in that the taxable consequence of those accounts is accelerated because we need to get rid of the funds in 10 years. Whereas a spouse has the ability to roll those retirement accounts into an account in their own name, and they don't need to take any distributions until they need to take a required minimum distribution once they reach whatever age will be required at the time that they're older. Currently, I think it's still 72 and a half, but we'll see what happens in 20, 40 or 50 when someone like me would be closer in age to needing to take those distributions. So that's the big issue with retirement accounts in general, is we don't want a 50-something same-sex couple saying, well, we're not so sure about this marriage thing. We've been together for 30 years and never needed to get married. Well, if you are a person who spent your lifetime maxing out your 401ks and have hundreds of thousands of dollars sitting in a pre-tax account, honestly, marriage is going to save your partner a lot of money in taxes, theoretically, than it would be if they had to take all that money out in that 10-year period while they still plan on working. And if they still don't want to be married in those circumstances, if marriage is 100% not a goal, then we can say, okay, well, what else do we want to do with this particular retirement account? Do we want to give it to nieces and nephews who are lower earners and therefore would pay lower taxes? Do we want to give a percentage of it to charity? If we have a charitable intent, why don't we do that with this retirement account instead of giving it to our partner because of the greater tax consequence? We can make decisions on, if you get married, this is what happens. Okay, if you do not want to be married, then these are ways that we can still make sure that you are getting the most of your money, that the money that you have upon your death is going where you want it to go, and not necessarily just to the IRS in the forms of taxes. Not that I am against paying taxes. Taxes are required to make the world go round, but it's my duty to make sure that we are not paying what we don't need to the government. These laws are written a certain way, and we want to make sure that our clients are getting the benefit of the way that the laws are written. So those are the big factors with retirement accounts. The other thing with retirement accounts in terms of protecting a spouse is if you are legally married and your retirement accounts are controlled by ERISA, so if they're 401k accounts through a traditional company, this does not apply to IRAs, then your spouse pretty much is guaranteed to get that account unless they consent to you listing another beneficiary. So this can be a protection for that surviving spouse. If you have a circumstance where one person supported the other through law school or med school, or they took time off to raise the children, where if they took time to not build into their retirement accounts the way that the higher earner did, marriage is a protection to make sure that they would receive part of those assets if their partner passed away. Because I have seen the circumstance, the same case I mentioned earlier, where my decedent, when he was 20 years old and started working at his job, listed his brother as the beneficiary of an account, and he never changed it with his partner, so his partner did not get that account. And that might not have been his intent. He might have just never thought about it. And I've seen that a lot, where people, even opposite sex couples, where if someone's worked at a job since they were 22 and they didn't get married until they were 27, they might have just never updated those beneficiary designations on their 401k. And that's very legally significant because of this non-spouse beneficiary rule, and because the surviving spouse now doesn't have access to these funds to take care of themselves
from Chicago
through
do a session in person.
retirement. Sorry,
When you have to like wear masks and make it all awkward and stuff.
here's someone
Why
talking.
not?
Okay. Sorry about that. So those are the things specifically with retirement accounts that we need to be concerned about for people who are not married versus people who are married. And then the same thing for retirement matters. There we go. for Social Security and pensions. Now, pensions are very, very fact specific. Basically, typically when you retire from a place that offers you a pension, they give you choices in terms of, I will give you the most money if this only works during your lifetime. If you only receive your pension while you are alive, we will give you 50 to 80% of the pension for the entirety of your life, but we will also support your spouse. We will give you 100% now, but after you die, your spouse only gets 50%. There's a lot of math with pension management and how those funds are distributed. But the big issue remains that if you are not legally married, a lot of the companies that would service your pension do not carry over that benefit. If you have a surviving spouse who, sorry, the talking was distracting. If you have a partner who is not a surviving spouse, and they might not get that pension benefit if they outlive their partner. And then with Social Security, it's very similar in that if you have a higher earning partner who is earning $2,000 a month in Social Security, and you have a lower earning partner earning $1,000 a month in Social Security, the surviving spouse, the spouse who lives longer, gets to choose whose Social Security they want to use. Do they want to use their partners, which is more, or do they want to stick with their own Social Security, which is lower? Obviously, it is better for them to pick the higher number if the higher earning spouse passes away first. So these are, again, more factors for marriage. If we have a couple who have been together for a very long time, but don't know whether or not they need to get legally married, this is a question of, well, in the circumstance where the higher earning spouse passes away first, this is what's going to happen. How is it going to affect your lifestyle if you do not have this Social Security check? And maybe for most people, it won't affect it very much, but this is just another factor to consider, and a factor to consider in your estate planning models of you can't assume the higher Social Security to a non-married couple. So if you are running your calculations on everyone lives out to 100, what if someone dies at 90? That's a factor that you're going to have to consider of the higher Social Security can't be assumed if we have an unmarried couple. So again, another benefit of marriage, the government wants you to be married. The government incentivizes marriage. And that just affects the way that we need to consider our plans and the way that we need to consider how we want to leave our assets, or how we want to even start saving for retirement if we know these facts, if we have no desire to get married. Now, the big thing that I really wanted to talk about for marriage in general, the biggest reason to have this discussion is probate estates, specifically because we're in Ohio. So again, the government likes marriage. They want to help surviving spouses in the circumstance that their spouse passes away. And this is particularly important for surviving spouses in the circumstance where an estate might be insolvent. So if you have a client who has $500,000 of assets, but they are upside down on their assets, they have lines of credit, they have credit cards, they were living outside of their means, and technically the way that their estate is currently, it's insolvent and the debts outweigh the assets, the surviving spouse still gets benefits from the estate that they would not get if they were not legally married. These rights include a right to receive the mansion house. The mansion house in Ohio is basically defined as any piece of real estate that the deceased spouse owned. You can basically pick whatever you thought the mansion house was in Ohio. But the benefit of this is if we have a circumstance where the house was only in one person's name, which is pretty typical because you and your spouse go to the mortgage broker and the mortgage broker says, well, spouse A has better credit and they earn more money and we'll get better rates if we only list spouse A and don't list spouse B on the loan. And if we list them only on the loan, then we only list spouse A on the deed. That's incredibly normal. I could probably list 4 couples that I know who are my age where that's the circumstance that happened. And if spouse A passes away with these debts, then we don't want the second spouse to get kicked out of their home because they need to sell the house for payment of these debts. So the right to receive the mansion house basically says that whatever the mansion house is in the estate, that you have the right to inherit it. So if you have a house that's worth $300,000 and the mortgage on the house is worth $280,000, the surviving spouse can say, well, I will get the first $40,000 of the estate as a allowance for support, which I'm going to talk about in a second. I want to receive this house with the lien on it as my inheritance, if that's all I'm going to get, and they can at least make sure that they receive the house. So right to place a lien on real estate, this goes back to that support allowance. So we're going to skip down 1 to talk about support allowance. Just so I feel like I've been talking to my camera for a very long time. Sorry. I'm trying to see how I can look at the poll for the Zoom chat.
Do you want me to create a poll for you?
Yeah, just for fun.
I'll do a poll.
I can't see the comments, but I was just going to ask, what do you think the allowance for support in Ohio is for surviving spouse? So Ohio law says we don't want our widows and widowers to end up on the street. How much money should we give them off the top of the estate? If we want to make the options, I don't know, 20, 40, and $100,000. I'm just curious what people will say. Okay, so the majority is correct. It is $40,000. I wonder how many of you cheated and had personal knowledge, but basically in the state of Ohio, if you have a person who has passed away, the spouse gets the first $40,000, basically no matter what. The way that the law is written, there are tiers of what creditor gets paid and what order. Tier 1 is lawyers and courts. We wrote the law, we want to get paid. Tier 2 is the surviving spouse getting that $40,000 allowance, followed by the funeral bill is also in tier 1. So funeral bill, surviving spouse, the government. So if you owe money to the IRS, the state of Ohio, and then the factors go down from there in terms of nursing homes are above, credit card companies. There's a list of who gets paid first. So basically 100% of tier 1 gets paid before anyone from the last tier gets paid. And that surviving spouse is the top person with that $40,000 allowance. So they can place a lien on real estate for that $40,000 allowance to make sure that if it gets foreclosed on or if it gets sold, they get paid first. They can use that $40,000 allowance to buy the mansion house in the circumstance that I explained before, where we have less than $40,000 of equity. They can just say, I'm going to take this and the little bit of equity it has as my support allowance, so I am not homeless. The right to remain in the mansion house. So under Ohio law, a surviving spouse has the right to live rent-free in the house of their deceased spouse for 1 year. And if they don't use that entire time to live there, they get the equivalent of what the rent would be to live in that house for that year. And that matters a lot when we have higher earning insolvent estates. I have seen insolvent estates of doctors and lawyers where the mortgage payments are $7,000 a month because they live in a incredibly expensive house in New Albany, UA, multi-million-dollar homes. So that's another benefit of being married is one, not only will you have the option to take the house if there's not a lot of equity. Two, you have the option to keep living in the house for a year, regardless of whether or not there's any equity. Three, you have the right to purchase the house at whatever the appraised value is. So you don't have to move if you can afford to live there. If you don't want to use your support allowance for the equity in the house, you can say, estate, you're allowed to sell this house, but you have to sell it to me for whatever the appraised value is. It doesn't need to go out on the open market. And you get a credit for that rent that you would receive for that year remaining in the mansion house if you decide not to live in the mansion house. So there are a lot of protections to make sure that we don't end up with homeless surviving spouses in Ohio, and none of those exist if you are not legally married. On top of that $40,000 support allowance, you also have out of probate benefits for receiving automobiles. So in the state of Ohio, you can receive up to $65,000 of vehicles without having to go through probate. So if your spouse was driving a, I don't know, Subaru Forester that's worth $40,000, you don't have to go to court to get that asset. You can just walk into the BMV with a copy of the death certificate, which again will list you as surviving spouse regardless of your gender because of a Obergefell, and just get that car transferred into your name without needing to go to probate court. Whereas if you're not married, even if you have a will that says, please give my Subaru Forester to my partner, by going through probate court, you are now subjecting yourself to claims against the estate by creditors. So if there is a $10,000 Macy's credit card, it is amazing how many people have Macy's credit cards, by the way. As a person who does estates, it is probably like the #1 credit card that I see. You don't have to pay that if you are going straight to the BMV and just getting the vehicle into your name. Same thing with right to watercraft. You get to get a boat from the deceased spouse without needing to go through probate. Right to reimbursement for the funeral bill. Technically, you would get this anyway, but the it's a specific list of the surviving spouse packet where if you basically spend up to $5,000 in the funeral, no matter what, you get paid before all of the creditors. And importantly, right to elect against the will. So a circumstance that I often see would be, again, we have a 22-year-old fresh out of college grad who wants to be very responsible. They're paying for a legal plan through their new employer, and they draft a will that gives everything to their brother, and then they forget about it for 35 years. They've been living with a significant other for the last 20 years, and then all of a sudden when they die, the will from 25 years ago is pulled out of the woodwork and presented to the court. Now, if that will did not exist and they were married, their surviving spouse would get everything, assuming that there are no children, asterisk, asterisk, under Ohio law. But if there's a will at all from any time in the past, that will theoretically controls even if you got married after. And the benefit of that marriage is you can elect against the will to basically receive half of the estate, asterisk, asterisk. It changes if you have children who are from a previous relationship, regardless of what that previous will says. So you're protected in both circumstances where if the person passed away without a will, if you are married, you will receive assets. And if they had a will from 100 years ago, you are still protected because you can elect against that will to receive a portion of the assets, regardless of what that previous will says, if it predates you, if it doesn't predate you, if they just try to write you out of their will because of spite or because you were soon probably going to separate but hadn't done it yet, you cannot legally disinherit your spouse in the state of Ohio. And therefore, you can still elect against the will to take the assets, at least half of the estate on top of that $40,000 benefit, on top of all of the benefits that we've already talked about. So being married, again, is incredibly legally significant in Ohio, particularly if your spouse passes away, because you have a lot of choices and a lot of protections in a probate court scenario. Now, I will say none of this matters in terms of assets that do not pass through probate if they have beneficiary designations, if everything is in a trust. Ohio is one of few states that actually does not have a way for a surviving spouse to pierce a trust that does not protect them. Other states, you can still get your spousal allowance, even if everything went to a trust outside of probate. Ohio, you cannot do that. Basically, if it is not in the estate, you do not have these protections. But again, these protections matter because it is very frequent that people miss assets, particularly houses in circumstances like I described, where you needed to only list one spouse on a mortgage, or vehicles where most people do not, even when they go to get their car title after paying off their car, most people just don't bother to place a transfer on death designation on the vehicle to give it to whoever they want upon their death instead of having it go through probate. So you have a lot of benefits of being a surviving spouse. And that's probably the biggest thing that that I wanted to address in terms of why should someone get married? If we have a same-sex couple and they're saying, well, we've gone all this time and we've never been married, why do we need this sheet of paper? This is a very legally significant sheet of paper. Getting married is probably the most legally significant thing that you will do aside from die. And therefore, I want to make sure, and you want to make sure when your clients are doing their planning, that they know, look, maybe none of this matters to you. Maybe you're going to have everything be non-probate assets, and therefore none of these protections matter. Maybe you're going to have all of your assets be joint, and therefore you don't need to worry about probate in general. Maybe you don't plan on saving in traditional retirement accounts. You want to keep everything in after-tax accounts because who knows what the tax rates are going to be in 2070. All of these are good reasons to combat the ideas that I've told you, but I just want to make sure my number one goal in doing any estate planning for any of my clients is you know what you're getting into. Here are all the things that can happen. This is what I'm trying to tell you. Whatever you decide is your choice. I just want to make sure that choice is an informed choice. And the big thing with estates, particularly insolvent estates, would be that the spouse has a lot of protections and that they get this allowance for support. They can buy assets from the estate for whatever the appraised value is. And that includes personal property. If the personal property is appraised at $2,000 for all the stuff that's inside of the person's house, you can buy all of that too. There's no need to sell it. You can guarantee protections to live in your home, to purchase your home, that $40,000 allowance, any assets that went to you outside of the estate anyway through non-probate means still get to you in the circumstance of an insolvent estate, regardless of whether or not you're married. So theoretically, we won't need to worry about a surviving spouse needing to change their entire lifestyle just because someone passed away. And that's our goal as financial planners also, is we want to make sure that we don't have clients who don't have adequate life insurance in case a spouse passes away prematurely. We want to make sure that their lifestyle can be maintained. And frankly, there are lots of circumstances where being married just makes that easier. So this section I've pretty much just titled Issue Spotting, Talk to a Lawyer, because it is so very specific based on the state that someone goes to in order to do any of these things, whether they're in Ohio or not in Ohio, the individual rules of the companies that you're working with for in vitro fertilization or surrogacy. There are lots of factors, both from the government perspective and from the private business perspective, on anything related to children for same-sex couples. So an example, if we have two assigned female at birth individuals, and one of them chooses to use in vitro fertilization to become pregnant, in pretty much all states, this is one of those like gray areas where the statutes are weird, but ideally, this is how it should work. It hasn't been litigated everywhere yet, but this is how it's supposed to work. If you are married to a person, they're the presumed parent of your natural born child if you are married. So assigned female at birth individuals, this is easy because if I do in vitro fertilization, I give birth to a child, and I am married at that time to another assigned female at birth individual. She is the father of my infant, even though she is not a male, because she is my spouse and therefore presumed to be the parent of whatever child I give birth to. That's a rebuttable presumption, theoretically, depending on whoever the baby's biological father is. They could try to establish parental rights. And again, this is where things get incredibly messy and there's lots of contracts involved. So these are all things where I'm just going to tell you, talk to a lawyer. I could not give this presentation in 20 minutes or an hour, even if I wanted to. But these are things that you need to consider. And you also need to consider in your estate plan of, there are circumstances where a couple might choose to do in vitro fertilization. They have eggs that are produced, embryos that are produced outside of natural conception. There are embryos in a lab somewhere. What happens to those embryos in the circumstance where one of the spouses passes away? And what happens in the circumstance where parent passes away, that embryo exists, that embryo is implanted, and that baby is born after the parent is already gone. So the way the law is written currently in Ohio, you can recognize the birth of children who are created after your death. But if you want to do so, there's a time limit on how quickly they essentially have to be born in order for them to count. And you can adjust that timeline in your estate planning documents. You can say, I have drafted the Amanda Straussbaugh Trust. If I have any children who are born through IVF within the first 5 years following my death, I want them to count and inherit under the terms of my will and trust. Now you might say, well, how are we going to divide up the shares of your trust if someone might exist in the next 5 years? Well, theoretically, if all my kids are minors, the shares of the trust aren't going to be divided up yet. They're going to be divided up when the youngest is 18 or the youngest is 22. So really, we don't need to worry about the divisions until later. So you can build in that exception of, I want to create human life that has my DNA. I have created embryos that have my DNA. I want them to be provided for, even if they are born after I have passed. Those are options. You can plan for it. And this is why I'm on team talk to a lawyer. Same thing for surrogacy. And that if you want to have an embryo created with your own DNA, you are a male, you're a same-sex gay couple, how are you going to give birth to that child? You would have a surrogate do so. What are the terms of that surrogacy agreement? You're going to pay for the hospital bills of the surrogate. That goes without question. Are there any rules around the surrogacy? All of these are things that you would need to consider and kind of build into the contract before you theoretically hire that surrogate, or before you have someone in your life volunteer to be that surrogate. If you are a same-sex male couple and your sister says, I would happily carry your child for you, there are legal things that we need to determine related to that process. Does a surrogate have any rights under the law? Depends on the state. Does the male partner of the husband have any rights under Ohio law? The law in Ohio is very much against unmarried fathers. If you are in a opposite sex couple and you are not legally married, and you don't say in some way that the child is yours, you don't go to domestic court to establish paternity, you don't draft a will that says this is my child, Ohio law just assumes that you're not the father. There is no presumption of paternity in Ohio. You have to affirmatively prove it. And in Ohio, even if we have a circumstance where a person gives birth and the other parent is the presumed parent, we still might want to do a step parent adoption just so we dot all of our I's and cross all of our T's associated with the rights for these children, because we do not want to have a birth giving spouse pass away and we need to double check with every government institution whether or not you are legally allowed to be the parent of your child. So basically anything related to children, we need to get lawyers involved. For adoption in Ohio, you cannot adopt a child as an unmarried couple, same sex or opposite sex. You need to be legally married for both of you to be the legal parents of that child. You can't adopt someone who does not have their parental rights given up if you are not a step parent adoption situation. Basically, again, Ohio loves marriage. Ohio wants you to be married. And if we have circumstances where we have a same-sex couple who are married, we still have considerations of, well, Ohio law is not great on this. They tried to change, I can't remember which statute it was, but basically there was some law that said husband and wife may blah, 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 blah. And Governor DeWine tried to basically cross that out and put married spouses, and it didn't pass because everyone was just like, well, why do we need to change the law? It's in effect either way. There's no point in adding this more inclusive language. We don't need to do that. So just given the legislature that we currently have of their proclivities towards same-sex relationships, we want to make sure that we dot all of our I's and cross all of our T's legally when it comes to anything involving children. And those are as deep as I wanted to go for in vitro surrogacy and adoption. All of them are very different beasts in terms of the legal requirements. And again, so much of this is state dependent, where, well, if both of our clients are Ohio residents, but the surrogate they use is their sister in Michigan, how does that affect what we're trying to accomplish? We need to be sure that we know what we're doing and who we have involved in the process. Other issue, Medicaid eligibility. So if we have a older couple where one person might need long-term care, they do not have long-term care insurance. The questions with Medicaid will be, what benefits would they have of marriage? Does it even make sense to be married depending on how their assets are titled? If we have two people who have completely separate finances, then it might not make sense to get married for Medicaid planning purposes. Honestly, there are circumstances where it can make sense to get divorced for Medicaid planning purposes. So if we have completely separate assets, that doesn't really affect it. But if we have a circumstance where the biggest asset is a piece of real estate in the name of the person who needs long-term care, then we have a circumstance where, once again, we have a surviving spouse who wouldn't get kicked out of the house by the government. The government does not want to kick widows out of their homes. So does that affect our decision to get married? Does that affect our decision to transfer the house out of the name of the person who might need the long-term care? How does that look in this circumstance? Do we want it to go to surviving spouse? If surviving spouse has the same situation where they might need long-term care. If we have an elderly couple, does it make sense to transfer the asset into some kind of irrevocable trust for the benefit of both spouses or one spouse to determine how do we best protect the asset from a Medicaid lien? Or if we can't protect the asset from a Medicaid lien, how do we at least make sure that nobody has to sell the home that they live in order to pay that Medicaid lien? other thing I wanted to touch on briefly, just because as a quote unquote younger person in a lot of these communities, there are circumstances of people who want to purchase houses together. Like if you have two couples who decide to go in on a duplex, or even if it's not a duplex, but they want to purchase real estate together, either in a platonic situation, in a polyamorous situation, in a, we have two traditional being monogamous couples, but they just want to live in the same place because buying a 4-bedroom house is easier than buying two separate smaller houses. There are circumstances where we want to just make sure, well, who is contributing what towards this real estate? Does it make sense to establish some kind of LLC where we own this property as a business instead of as 4 individuals? How are we going to consider contributions towards the property of if one couple pays for new appliances, or one member of a group of people pays for a new roof? How are we going to factor that into the equities decisions related to the real estate? There are lots of factors, and you might run into this more. Real estate in Franklin County is hilariously expensive if you have not noticed. And this may be a situation that comes up more. And again, this is another where if you have someone talking about, oh, well, I'm thinking about buying a house with a friend or a group of people, or I'm going to buy an apartment complex with some of my buddies from college, and each of us are going to live in a unit. These are all things where we just want to get a lawyer involved to hammer out the long-term details of what happens in this situation where the roof is leaking, what happens in this situation where one of our partners goes bankrupt. How are we going to figure this out? And this is an issue that I think will come up more. Maybe I'm wrong. Maybe the housing market will stop being incredibly expensive, but I am not a fortune teller. And then multi-generational households. This is less of an issue in same-sex couples, just because, as we discussed before, there are occasions where there's a lot of animosity associated with previous generations. But if we have a circumstance where we have parents and child and their spouse and grandkids all living in the same place, and that house is in name of elderly parents, how do we want to figure out planning for, well, do we want the children's names on it now? Do we want to sell it to the children? Do we want to establish some kind of trust? Do we want to establish some kind of LLC? What are we going to do to make sure that everyone's interests are protected in the home that they live in? So again, all of these are big picture. Please talk to a lawyer, or advise your clients to talk to a lawyer to make sure that they are protected from the financial difficulties that can be associated with any of these processes. Because I will tell anyone who will listen to me that my least favorite thing in the whole world to do are partition actions, where if you have a couple, they own a house together, they're splitting up, one person wants to force the sale of the house. It's a mess. It's expensive to do. It's never a circumstance where parties are cooperative because something has happened that is making them split. It's better to plan for these things in advance, so we know going into the problem what the possible solutions are, as opposed to not planning in advance for that potential problem. And those are all my slides. If anybody has any questions, I don't know how we're asking the questions.
Amanda, it sounds like this is Chris, by the way. It sounds like there are, at least listening through this, two kind of key issues that it's really helpful to not rely on just our expertise, but to get a lawyer involved. And that's when it's involving kids, and it sounds like involving real estate. Am I hearing that correctly?
Yes, I
Okay.
100% agree with that statement.
Okay, because it sounded like some of the other things are like, okay, you can talk them through steps to take, but those two, it's like, that's out of my wheelhouse.
Yeah, because I stand by the fact that a lot of, because because I mean, and obviously I'm not a CFP, like I did not further on financial planning, but just in the financial planning spaces on the internet that I continue to hang out in, just because it's something that I was obviously interested in since it's my major. There are ways to plan around pretty much everything else in terms of retirement assets. Honestly, a lot of people are, I feel like a lot of more people are afraid to use 401ks and traditional IRAs because of the uncertainty of future tax brackets. A lot more people are using Roths and just after tax accounts in general. Like I feel like the circumstance that a lot of like I don't want to say boomer because I feel like it's become somehow like charged, but like baby boomer circumstances where you have a pre-tax account with $500,000 in it, I don't see that happening as frequently in the future just because of the way that the tax circumstances have been. And therefore, I think that that's less of an issue. But in the circumstances where we have two living people and they want to plan something, children and real estate are the two things where I would want to talk to someone. And then if we have a circumstance where someone has passed away or might pass away, if we have someone who's recently been diagnosed with cancer, then we might have a circumstance where, unfortunately, it'll make sense to get married. If they have a lot of debt that is not forgivable at death, then there are protections that a surviving spouse has against insolvent estates that might warrant action in that circumstance. But
So follow-up question to that in regards to the real estate. Can you just explain to me, and I probably should have caught this from the presentation, so apologize. But where you said they can live in the house rent-free for a year, a spouse can. Does that mean that if the spouse is in multi-million-dollar mansion with the $7,000 mortgage, like you gave the example, does that mean that they can live in that house for a year without making mortgage payments? Is that what that means?
it's kind of weird. So in the circumstance where if we have an expensive piece of real estate with a mortgage and the estate's insolvent, then we would want to file an action in probate court that can stop foreclosure. So that's one of the biggest that's a big tool that probate lawyers can use in the circumstance where we have either the estate's upside down because of the mortgage. If we have an overextended house, I think that's something we're going to see in the future again more. It hasn't happened recently, but it was an issue, obviously 2008. But you could open an estate, file a land sale action with probate court saying, hey, court, we have this house. We think the estate is insolvent. Therefore, let us sell this house through the probate court process and proceed any foreclosures. So that's a big benefit of Ohio law, is we can stop foreclosures from happening in the first place when the mortgage holder has passed away. And at that point, once that land sale action is established, then we can talk to the mortgage company and say, look, the mortgage for this house is $5,000 a month. The surviving spouse has a right to live here rent-free for a year, so we can keep this action open and preclude your foreclosure for the next year. Do you want us to do that, or will you let us sell the real estate and we adjust your lien payment 5,000 times 12, or if we're trying to be nicer, 5,000 times 10 or 11, to allow for the house to get sold faster and the surviving spouse to move on faster, as opposed to living in a house for a year that they theoretically can't afford. So that is a thing that's, honestly, I think it's one of the biggest benefits for, and again, in the circumstances where we have insolvent estates, where we have someone who owns a business and therefore has a lot of loans in their individual name, where we have someone who is overextended on their mortgage because they've maxed out a HELOC because they wanted to start flipping houses on the side. There are circumstances where we have insolvent estates and real estate is our big factor, and we have a surviving spouse who, even in the best circumstances, might not be able to afford that $4,000 mortgage, or even if the mortgage is paid off, maybe they don't need all that space. Maybe they don't want to pay that much in property taxes. There are lots of reasons why a surviving spouse will want to move anyway. But that year mansion house allowance is something we can use as leverage to say, even if we don't use it, we have the right to it. So therefore, it's basically another kind of spousal allowance that we can use to negotiate with creditors.
Thank you.
If anybody else has any questions, feel free to unmute yourself and share your camera and ask question. All right. Well, Amanda, I think there was a lot of, share my camera again, eye-opening points that you made. And like Chris said, especially with children involved and in vitro and all of those situations that we might quickly gloss over those details without realizing the lasting implications of what is going on with that. So there's tons of conversations that can be had on all this stuff. So appreciate you bringing that awareness to all of us. And even if it just means we know when to call somebody for help, that's probably a huge takeaway for all of us to have. So again, thank you so much. I know everybody here is applauding you, virtually for sharing with us right now. That was really helpful. Again, everybody, thank you for joining us. Make sure that you mark your calendars for next month's presentation as well. And show some love to all of our sponsors because they really help us out. So, all right, everybody have a great rest of your day and we'll see you next time.
Thanks, Amanda.
Thank you.